he is saying by stating, but I don't want to leave the meeting because I have to be here for court. I don't want this on YouTube. That's not a.
Sorry. All right, court, as I've just said, court takes full judicial notice of all the prior proceedings and the contents of the file. I need to go over these written plea admonishments and stipulations of evidence with you, Mr. Bowman. They should be going up on the screen. The original charge, the original indictment in this case was for driving while intoxicated, third offense or more. You understand that if the court grants the state's first amended motion, if the court grants the first amended motion to revoke community supervision, finding the allegations therein to be true, the court would go back, finds you guilty of the offense of driving while intoxicated, third or more, that's a third-degree felony, and then you could be sentenced up to 10 years in the Texas Department of Corrections Institutional Division. That is on the state's exhibit, or will be a state's exhibit, written plea admonishments or stipulations of evidence. Do you understand that?
Judge, I'm not trying to interrupt, but it looks like we've lost the defense attorney and the defendant.
Okay, it's probably a good time to interrupt. I was looking at the documents, not looking up.
Hello, can you hear me?
We can hear you. We cannot see you. There. Okay.
Hello. Why don't you move?
Okay. Why is the screen split?
I don't know. Why don't you move it over here? Are you there? Okay.
Yes. All right.
Now we're going. Mr. Bowman was concerned about this being on YouTube.
If we have a hearing via Zoom, it is required that it be live on the court's YouTube page.
Does that mean it's broadcast to people anywhere or?
On our page.
On your page, okay.
It's no different than an open courts provision. That's why the rule is what it is. Anybody could walk in if we were doing this in court. And so part of the OCA's requirements is that Zoom hearings are to be broadcast. So
I'm on Travis's computer and I don't know where this stuff goes.
he wouldn't be able to prohibit someone from walking in and watching the plea if he was in regular court. So that's,
I got you. I understand.
I'm sorry about that. I guess this does go live on YouTube or whatever. That's a true. Yes, sir.
Hey, this is just as if you were in open court, anyone can walk in and view the proceedings. So this is not on general YouTube, but it's on the court's page. So if anybody wanted to access it on the court's page, they could do that.
Okay.
Okay, Judge, I think we're ready to proceed.
Okay, let me be sure Denise is ready. Keep losing. All right, I got on the screen Mr. Chamness, Mr. Mason, Marcella, my probation officer, and the defendant. But I don't have back in front of me because Denise had taken it to look something up. I don't have the, I believe it's the first amended motion to revoke. Okay, here you go. I got it back now. All right, Mr. Bowman, have you gone over the state's
Yes, sir.
first amended motion to revoke, which alleges the violations they have for, obviously, for violations of your probation?
Yes, Your Honor.
Okay, have you gone over that with your attorney, Mr. Mason?
Yes, Your Honor.
All right, you do understand then all the allegations in the state's motion to revoke your probation. Actually, it's the state's first amended motion to revoke your probation. You've been over it with Mr. Mason. You understand all the allegations in the state's first amended motion to revoke your probation. Is that correct?
Yes, Your Honor.
And the court does take and already has taken full judicial notice of all the prior proceedings in the case. This document I need to go over with you, and this cause number 241-1274-16, State versus Tommy Bowman, is going up on the screen, or should be going up on the screen. It's the written plea admonishments and stipulations of evidence that I need to go over with you. You've reviewed that first submitted motion to revoke community supervision with your attorney, as you have told me. Also, I have the written plea admonishments and stipulations of evidence. When they go up on the screen, they'll be in front of you, because I'm going to need to ask you if they're signed by you, and then I'm going to swear you to them. Right now, I don't have them up on the screen in front of me.
I don't either.
Judge, to make it clear, we've agreed to paragraphs 2, 3, and 4 as true on the first amended motion, but we have not agreed to paragraph 5, Roman numeral 5. And I think
Let me get it up on the screen, because I'm going to need Mr. Bowman to look at. There it is now. It just came up. So, Mr. Bowman, if you look at that document right there,
Yes, sir.
Written plea admonishments and stipulations of evidence. Have you been over that document with your attorney, Mr. Mason, who's here on Zoom?
Yes, Your Honor.
Okay. Let me swear you to this document. Just raise your right hand. Do you solemnly swear that the written plea admonishments and stipulations of evidence marked as a state's exhibit on the screen now is true, that all the information therein is true and correct, so help you God?
Yes, sir.
All right, that is your signature, Mr. Bowman, there on the line where it says defendant, correct?
Yes, sir. Yes,
All right,
sir.
It's signed also by your attorney. It's now signed and sworn to. Up at the top, of course, it shows the original criminal charge with driving while intoxicated, third-degree felony. The maximum you can receive is up to 10 years. Shows your attorney, Mr. Mason, on here. There are 4 explanations. They're called admonishments 1, 2, 3, and 4 right there at the top. Do you understand those 1, 2, 3, and 4?
Yes, sir.
Then coming on down into the next paragraph, you say, which is correct, and you're stating that you fully understand and have read these foregoing admonishments 1 through 4, as well as the allegations being made against you in the state's motion, first amended motion to revoke your community supervision. In other words, you've gone over the first amended motion to revoke your community supervision with your attorney, Mr. Mason, so you understand the state's allegations which allege violations of your probation. Is that correct?
Yes, Your Honor.
Now, coming on down into that next paragraph, you'll see where it says, understanding the foregoing, that's 1 through 4, that you and your attorney, you state to the court that you fully understand and have read the foregoing admonishments, as you've told me you do, as well as the allegations against you in the state's motion to revoke your probation, as you've told me you do. And then you state right there in that sentence, understanding and the admonishments and allegations, you make the following free, knowing, intelligent, and voluntary stipulations of evidence. You are the individual whose signature is on this document. You're the individual appeared in court today who was the same person placed on probation for the offense of driving while intoxicated in this cause number. Is that correct?
Yes, Your Honor.
Now, the next paragraph up on the screen, and you can see it, you say that the allegations as set out in paragraphs
2, 3, and 5. 4.
I'm sorry.
2, 3, and 4.
All right. Okay. All right. That the allegations are set out in paragraphs, I can see it now, 2, 3, and 4 of the state's motion to revoke your probation are true. Is that correct, Mr.
Yes,
Brown? Is that correct?
Yes, Your Honor.
Okay. And then you are saying that you are entering pleas of true to the allegations in paragraphs 2, 3, and 4. Is that correct?
Yes, Your Honor.
And you understand entering those pleas of true to the allegations in paragraphs 2, 3, and 4 of the state's motion, first amended motion to revoke community supervision, the net effect of those true pleas will be that the court will find those allegations true based on your pleas of true, and then the court will grant the state's first amended motion to revoke your community supervision. The court will go back, order your community supervision revoked, again, find you guilty of the offense charged in the indictment, driving while intoxicated, a third-degree felony, and then the court will assess your sentence somewhere between 2 and 10 years in the Texas Department of Corrections, a fine of up to $10,000. Do you understand all that?
Yes, Your Honor.
Understanding all that, do you still stipulate and enter pleas of true to the allegations in paragraphs 2, 3, and 4 of the state's first amended motion to revoke your probation?
Yes, Your Honor.
All right, the court having received and accepted into evidence the written plea admonish and stipulation of evidence, what number you want to put on that, Mr. Chamness?
Your Honor, that would be states 5, and while we're on this, the state is abandoning paragraph 5 of the motion. That was something that Mr. Mason and I had talked about. The defendants pled true already to paragraphs 2, 3, and 4, and so we're going to abandon paragraph 5, but this would be State's Exhibit 5.
All right, and paragraph 5 of the state's first amended motion is abandoned by agreement of the council, and states Exhibit number 5, the written plea admonishments and stipulations of evidence signed by the defendant, Tommy Bowman, over the line where it says defendant, it's signed and now sworn to, also signed by his attorney. States 5, the written plea admonishments and stipulations of evidence are admitted into evidence with no objection. Correct, Mr. Mason?
Correct.
Court having admitted into evidence, State Exhibit number 5, the written plea admonishments and stipulations of evidence. The court does grant the state's first admitted motion to revoke community supervision. The court orders the probation earlier assessed on the date reflected in the record to the defendant, placing him on probation for offense of driving while intoxicated. State's first admitted motion to revoke that probation is granted. The court does find the defendant guilty of the offense of driving while intoxicated, a third-degree felony as alleged in the state's information. Moving to sentencing, you have a recommendation or agreement, Mr. Chamness?
We do, Your Honor. Mr. Mason and I had discussed this case months and months and months ago, but the defendant was not in our custody. There was some business, which is part of what he pled true to, involving another county. And so our recommendation, or we agreed that we would run our probation revocation concurrent with what he received in Houston County after talking to the DA there. So it's for 3 years confinement in the institutional division.
Correct, Mr. Mason?
That's correct.
All right, the court in this case then, having granted the state's first admitted motion to revoke community supervision based upon State's Exhibit 5 containing the defendant's stipulated and entered pleas of true to the allegations in the paragraphs 2, 3, and 4. Court having granted the first admitted motion to revoke community supervision, the court does again find the defendant guilty of the offense of driving while intoxicated, a third-degree felony, as alleged in the indictment, and the court follows the agreement and assesses the sentence at 5 years in the Texas Department of Corrections Institutional Division. 5-year sentence is assessed with credit for time served.
Judge, it's 3.
All right, the court then strike that. The court in this case, having granted the state's first admitted motion to revoke community supervision, orders the community supervision probation of the defendant to hereby be revoked. The court again finds the defendant guilty of the offense of driving while intoxicated, the third-degree felony as alleged in the indictment, and the court, following the agreement, assesses the sentence at 3 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Any restitution?
No, Your Honor.
No restitution is indicated as due. Sentence is formally pronounced at 3 years in the Texas Department of Corrections Institutional Division with credit for time served. No restitution is indicated as due. I have from you, Mr. Bowman, a waiver of appeal that was originally filed when I placed you on probation. Do you understand that waiver of appeal, that you are waiving your rights to appeal from this revocation proceeding? Do you understand that?
Yes, Your Honor.
All right, it'll be the order of the court then, Mr. Bowman, you're continuing the custody of the sheriff until you can be transported to the Texas Department of Corrections Institutional Division to serve the 3-year sentence assessed in this court for the offense of driving while intoxicated, a 3rd-degree felony, as alleged in the indictment. The 3-year sentence is assessed with credit for time served. Restitution is ordered if there is any, like if there may be if there's a blood test, restitution to be ordered DPS on it. Sentence is formally pronounced. Now, you understand, Mr. Bowman, I mentioned it, but you've signed and in the file are waivers giving up your right to appeal and waivers giving up your right to file a motion for new trial. Do you understand that?
Yes, Your Honor.
Are you waiving that right to appeal and waiving that right to file a motion for new trial freely, intelligently, knowingly, and voluntarily?
Yes, Your Honor.
All right, anything further, Mr. Chambliss?
No, Your Honor.
Anything further, Mr. Mason?
Your Honor, just, is there a box or something that you check on the judgment for concurrent with the Houston County?
It would actually not, it wouldn't be a check by a box. It would be on the judgment itself. I'll just ask Mr. Chambliss to get with Denise or Tabitha and he'll have the language to go on the judgment to show it's running concurrent with the time assessed down in, what was it, Houston County, Mr. Chambliss?
Yes, Your Honor.
All right, just get with Tabitha, would you, Mr. Chambliss? Be sure that's on the judgment, then I'll sign it.
All right, thank you.
If there's nothing further, the defendant, Mr. Bowman, is continued to the custody of the sheriff until he can be transported to the Texas Department of Corrections Institutional Division to serve the sentence assessed by the court. Sentence assessed by the court for the offense alleged in the indictment is assessed with credit for time served in order to run concurrent of the sentence counsel has referred to down in Houston County. Waiver of appeal is accepted. Anything else, Mr. Mason?
Your Honor.
Anything else, Mr. Chambliss?
No, Your Honor.
All right, we're in recess.
I love you, Steve. Love you, Huey.
Thank you.
Thank you, Steve.
Well, so we did get concurrent on the record with,
Yes,
Houston
Houston
County.
County, which is the earliest one.
I don't believe that that's settled.
Yeah.
Okay, so the only thing, bro, is I wish,
So it probably goes 3 years from September 23rd of 2019, which is the day that they moved to revoking. But Houston County was September 21, 2 days earlier.
right, so,
They run together. So